The U.S. Supreme Court has ruled that race can no longer be taken into account in university admissions. The decision overturns decades-old policies regarding affirmative action in higher education. Here's what that means for hundreds of thousands of Americans. Also known as positive discrimination, affirmative action first came about in the U.S. in the 1960s as a way to mitigate discrimination for minority races and ethnic groups. Against the backdrop of the civil rights movement, President John F. Kennedy issued an executive order in 1961 mandating affirmative action to prevent racial bias in employment practices. A few years later, President Lyndon B. Johnson signed another order banning discrimination in various situations, including schools and government services. Two cases involving admissions at Harvard University and the University of North Carolina were brought before the Supreme Court in October 2022 by a group called Students for Fair Admissions. The nonprofit group, which was formed by conservative activist Edward Bloom, first filed lawsuits against both schools in 2014. It argued that Harvard's admissions policy related to race infringed the Equal Protection Clause in the U.S. Constitution, which prohibits discrimination based on race, color, or national origin. The group called for the overturning of earlier Supreme Court decisions that maintained otherwise. The court's conservative majority was inclined to agree with the plaintiff, ruling 6-3 against UNC and 6-2 against Harvard.
These opinions reestablish the founding principles of the 1964 Civil Rights Act, which clearly forbids treating Americans differently by race.
There are concerns that the end of race-conscious admissions will affect the future college admissions of certain demographics and underrepresented groups, as well as enrollment procedures across the U.S., especially in Ivy League universities. Harvard has said it will comply with the court decision, but that does not change its values.
The Supreme Court's decision on college and university admissions will change how we pursue the educational benefits of diversity, but our commitment to that work remains steadfast.
Already, bans on race-based college admissions are in effect in 9 U.S. states. Those are Arizona, California, Florida, Idaho, Oklahoma, New Hampshire, Michigan, Nebraska, and Washington. Experts say previous bans saw a drop in enrollments from minority races that were later partially recovered. In 1996, when California banned affirmative action, enrollments at Berkeley and the University of California fell 40% among Black and Hispanic students. To create a diverse student body following the ban, UCLA has invested millions of dollars in outreach programs and in diversifying their student body. A recently released Pew Research Center survey found that half of Americans disapprove of considerations of applicants' race, while a third approve. President Biden has said he strongly disagrees with the court's decision.
Discrimination still exists in America. Today's decision does not change that. It's a simple fact.
Former President Donald Trump welcomed the move, vowing to remove all diversity programs if re-elected.
To vigorously enforce yesterday's Supreme Court ruling, I will eliminate all diversity, equity, and inclusion programs across the entire federal government.
Former President Barack Obama said affirmative action gave a chance to generations of students who had been systematically excluded from most of America's key institutions. Critics have argued that legacy applications across elite U.S. colleges and universities are also discriminatory. On July 3rd, 3 civil rights groups lodged a complaint against Harvard, alleging that its existing policy for undergraduate applicants with family ties to the institution disproportionately benefits white students. Although the Supreme Court reversed an almost 40-year precedent, it still gave some allowances for college and university admissions staff to consider race in admissions essays. President Biden has urged colleges to consider hurdles prospective students may face.
If a student had to overcome adversity on their path to education, the college should recognize and value that.
Affirmative action remains a key point of contention in American education. Universities and colleges are looking to get a better understanding of the court's decision in relation to future admissions policies. They will now have to find alternative ways to ensure their student bodies are diverse.
The Supreme Court has just made our fight for racial equality that much harder.